back to ABHI Law, where law is simplified. This is Advocate Shama Patnigere, and today we are going to continue our topic on the law relating to women and children. In our last video, we saw how the Constitution of India protects women's rights. In today's video, we are going to learn a little deeper about a landmark judgment given by the Supreme Court in this regard, and also the law enacted for the protection of women against sexual harassment in their workplace. Come, let's look at the landmark judgment given by the Supreme Court. Vishaka and others versus the state of Rajasthan. Vishaka and others versus the state of Rajasthan is one of the most landmark judgments given by the Supreme Court of India, which redefined and ensured that a mechanism for the protection of women's rights, for protection of women against sexual harassment was enacted. Now, the Supreme Court in this judgment gave directions and ensured that guidelines were issued to ensure that women did not face sexual harassment at their place of work. Let's look at the facts of the case, the guidelines that were issued, and the law that later came into existence, which is the Prevention of Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. Vishaka and others versus the state of Rajasthan, as I have been saying, is a landmark judgment by the Supreme Court that deals with the evil of sexual harassment of women at workplace. Sexual harassment of women at workplace is a phenomenon that has existed in our society for a really long time, and it puts women at a higher level of risk when they are working. Now, it was important to set up a mechanism, a robust mechanism that dealt with this evil and that could safeguard women's rights when they were working. The decision of the Supreme Court in this regard laid down elaborate guidelines and issues to deal with this menace. Facts of the case. Before we look at what judgment the Supreme Court gave, the guidelines that were issued, let's look at what transpired, what happened that led to the Supreme Court giving this judgment. Bhaveri Devi, a social worker in Rajasthan, was brutally gang raped by 5 men of the upper class for stopping a child marriage in the year 1992. Bhaveri Devi now was very determined to get the offenders punished. However, due to lack of evidence, the accusers were acquitted by the trial court. Bhaveri Devi, however, did not give up her fight against this injustice. She, along with her husband and other members of the social organization that she was associated with, continued their fight against the wrong that had been done to her. Several women's groups and NGOs then filed a PIL, a public interest litigation, in the Supreme Court under a collective platform called Vishaka, which asked the Supreme Court, the apex court of India, to give certain directions, lay down certain strict rules to prevent the sexual harassment of women at their workplaces. What was sexual harassment of women and how was it a violation of women's human rights? We saw in our last video how the Constitution of India safeguards women's rights. Now, according to the incidents that took place during this case, we look at a number of articles of the Constitution that protect and safeguard women's rights that were infringed. Article 14, equality before law. Article 15, prohibition of discrimination on the grounds of religion, race, caste, sex or place of birth. Article 19(1)(g), it gives us the right to practice one's profession or to carry on any occupation, trade or business. And Article 21, our right to life and personal liberty. All these are at one point infringed when someone is sexually harassed at their workplace. Now, sexual harassment can be defined as any unwelcome sexually determined behavior by the person of the opposite sex, physical contact and advances, sexually colored remarks, making remarks about someone's sexuality, demanding or requesting for sexual favors in return for a promotion, showing pornography, any other unwelcome contact of sexual nature which can be verbal or a non-verbal form, or which can also be physical, spreading rumors about a woman's sexual relationship with anybody, or anything at a workplace that can place the working woman at a disadvantage compared to other men working against her in the same category just because she is a woman, can be termed as sexual harassment. Guidelines. In its judgment, the Supreme Court provided a set of guidelines, a set of directions to employers as well as anyone else who is responsible for institutions to immediately ensure that provisions were made for prevention of sexual harassment of women. These guidelines were formulated since the then civil code and penal laws in India did not adequately provide for specific protection of women from sexual harassment in their workplace. Now, in accordance with Article 141 of India's Constitution, these guidelines were to be considered law until appropriate legislation was created. Let's look at a few guidelines. Let's look at these guidelines. Okay. The first one is the duty of the employer. Whenever someone employs someone, it is their duty, the duty of the employer or any other person who is being responsible of the workplace to ensure that all these guidelines are set in place. Second were the preventive steps. What are the preventive steps that an employer or any other responsible person can set up in place to ensure that such incidents do not take place? Criminal proceedings. How can a person who has faced or is a victim of such harassment can take criminal action against the offender? Disciplinary action against those who have been convicted of committing such an offense. Complaint mechanism, to set up a mechanism where a victim would have the confidence and the freedom to approach the committee, informing them about this event that has taken place. A complaints committee, setting up a complaints committee in organization which will allow women the freedom to openly approach the complaints committee and inform them about any such incident. Workers' initiative. It was important that workers together took the initiative to come forward and make their harassment known. Awareness. A lot of women, like we discussed in our previous class, were still not aware about the rights that they have. Women working in a workplace have the right to raise their voice, yet some of them are still unaware about this. Any third party that is then involved in such an incident or needs to be involved in such an incident can then be taken into consideration. Now, the Supreme Court also laid down that it shall be the duty of the employer, or as we discussed, any person in charge, to take all necessary and reasonable steps to assist the affected person in terms of action and preventive action and support. No prejudice, however, of any of the rights that are available under the Protection of Human Rights Act 1993 can occur just because someone has taken the help of these guidelines. Once this Supreme Court judgment was laid down in the year 1997, it was only in 2013 that Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013 came into force. Let's look at this act a little closely. Let's look at the salient features of the act. This act superseded the Vishaka guidelines. An entire mechanism was set in place to ensure that women who face such harassment have a correct mechanism, have correct guidelines, have correct steps and procedure to follow to ensure that they do not become victims of such harassment. The Sexual Harassment of Women at Workplace Act makes it completely illegal to sexually harass women in the workplace. Now, this act is only for women who are sexually harassed in workplaces. However, this act is for any woman who is harassed. It is not necessary for the woman to be working at the workplace in which she is harassed. A workplace can be any office, government or a private institution. What is workplace sexual harassment? Now, the Act defines workplace sexual harassment as any behavior that is either unwelcomed or sexual in nature. What is sexual harassment? Again, physical contact and advances, demanding or requesting sexual favors, showing pornography or sexually colored remarks. When all of these acts come together, or if either of these acts are committed and a person feels that their personal space or their personal right is infringed in any way, when a woman feels that any remark about her makes her uncomfortable, she can call it sexual harassment if it falls under any of these categories. Now, it is the duty of an employer to set up an internal complaints committee. An internal complaints committee consists of the following members. One presiding officer, who will be a senior woman employee from the workplace, any other administration unit or office or organizations. Two members who are committed to the cause of women, who are experienced in who have experience in social work or have legal knowledge, and one a member from outside, from any NGO or other women's rights activist group who are familiar with issues relating to sexual harassment. This act defines sexual harassment at the workplace. It creates a mechanism for redressal complaints. Whenever a woman faces sexual harassment at her workplace, there is a procedure and a step to be followed for redressal of complaints. It also provides to safeguard women against false or malicious charges. Now, if there were no cases of sexual harassment at the moment, it is still necessary for employers for the committee to be set up. The Internal Complaints Committee, irrespective of whether a sexual harassment case has been instituted or not, an event has taken place or not, an Internal Complaints Committee, if an employer employs more than 10 workers, needs to be set up and the rules have to be followed by all. This act talks about the different ways in which someone can be sexually harassed and how can they complain against this wrong behavior. Now, the act gives you a choice between dealing with your offender within your organization through this Internal Complaints Committee, or it also gives you a choice to approach a court and file a criminal complaint. If you wish to file a criminal complaint, instead of approaching your internal local complaints committee, you can do so. Every employer is required to set up this Internal Complaints Committee at every branch in case there are 10 or more employees working at one place. The district officer is then required to constitute a local complaints committee at every district, and if required even at a block level. Now, once a woman files a complaint of a sexual harassment incident and the Internal Complaints Committee is then apprised about this situation, the committee is required to complete the entire inquiry within a time period of 90 days after the receipt of the complaint from this victim woman. On completion of the inquiry by the committee, the report will then be sent to the employer or the district officer as the case may be, and then they are mandated to take action on this inquiry report within 60 days. The complaint committees have been given powers of civil courts to gather evidence. In the event evidence is needed, people have to be summoned, witnesses have to be questioned. The complaint committee has such powers to do so. The complaint committees is required for conciliation before initiating an inquiry if requested by the complainant. Now, if the complainant does not wish to directly take action but calls for a conciliation, the complaint committee will then be required to call for a conciliation meeting before inquiring into the matter. This is what the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act is all about. This was just an overview. In our next video, we are going to see how this act lays down specific rules for giving your complaints, how the Internal Complaints Committee is required to complete their report, gather evidence and give their report on the matter. We are also going to look at a few examples in our next video as to what constitutes a sexual harassment offense, what does not, and how this act is being misused in certain parts of the world. Thank you for watching ABHI Law. We look forward to seeing you in our next video.